Hi, my name is Joanna Torch. I have a business called Family Law Cafe. I'm a family law barrister and I'm having a chat today live to talk about what happens at a final hearing in a children case. So, talking about final hearings in a children case, and I thought this would be a good subject because I know that lots of you might be going through children proceedings and you're going through it, but you don't have any knowledge of what a final hearing will look like and what will happen in a final hearing. Because, of course, children matters are kept private, so they don't let anyone just walk in. And so, you don't have a way of just going along and watching someone else's case. You have to be involved. And, of course, the court wants to make sure that children's privacy is respected, and so they're not going to just let anyone wander in. So I thought we could have a chat about that, and if you've got any specific questions as we go along, put them in the comments, and just make the comments down below, and I can see them as I'm talking, and if I can, I'll pick them up and address them. So firstly, to talk about this, that there's two types of children cases. There's children cases which involve the state taking a view about your care of the children, might have to intervene if they're, for example, the care isn't good enough because perhaps a parent suffers from drug issues, alcohol issues, mental health issues, or there is other issues leading to just child not being looked after properly. Then they will obviously try to step in and help. They want to take children away from their parents unless it absolutely has to happen. But if after that help it hasn't worked, they would start proceedings, and that means that in that case the child would be represented by a guardian, and the parties in that case would be the local authority, the parents. There could be some interveners, different circumstances, so other parties, and the guardian who looks after the interest of the child. So there will be a lot of parties in that case. And so in any hearing, sort of people that come in before the judge, and in those type of cases, if it came to a final hearing, then what would happen is the local authority presents the case, and then the respondents are, usually they put the mother first, mother, father, could be an intervener like a grandparent, maybe seeking a special guardianship order, and then the guardian would go last. And so the order that things would happen is that the local authority presents the case and presents it neutrally, and then the other parties are responding. So that's one type of case. That's the public law case. The other type of case is private law children proceedings, when it's generally one parent having a different view to the other parent. It hasn't been resolved in mediation, it hasn't been resolved during the proceedings, come to a final hearing. There would usually be a CAFCAS report, and in that case usually the people that would be in court would be, let's say it's the father applying for more time with the child than the mother is prepared to agree to, and it comes to a final hearing. That would be one example. Then the father would be the applicant, and the mother would probably be the respondent. So there could be a different scenario. It could be a different parties in private law proceedings, which usually the parents, the father, the mother, or it might be the mother who's the applicant. It just depends on the factual situation. And usually there usually wouldn't be another party unless very unusually and exceptionally the child had a guardian, in which case there would be a guardian who would appear for the child. So usually just two parties, and there would usually be a CAFCAS report. So there would be a family court advisor who's prepared a report. So so there's two different scenarios. So let's look at what would happen in a final hearing in a care case, just as an example of a public law case. And I'm just going to give you the broadest of outlines, because That's the intention. It's a live. We've got 10-15 minutes just to talk about it, just to introduce and give you some ideas. Of course, you can send direct messages to us, and if there's any particular questions, or put your questions in the comments below, I'll try to answer them. And in that scenario, case would probably be listed. It might be listed for 3, 4, 5 days. It really depends how many witnesses there are. And it would be opened by the local authority who would explain to the judge what the case is all about. And there would be a court bundle that would have been agreed in advance, and there would be documents they would refer to, but they would explain the case, and that's called an opening speech. Could be very brief, usually is in children cases, because the documents have usually been read by the judge, and they might say, are you familiar? Have you read, the case summary, chronology, and then just give a brief opening. And the local authority would then call their witnesses, and the witnesses would generally be a social worker. It might be a previous social worker who had dealings with the matter. So whoever they're relying on to prove their case. And you only call witnesses if other parties have a dispute about what they say. Because if a witness is agreed, you wouldn't need to call them generally. So the first witness would usually be social workers, and then in a care case, usually people are represented because you get public funding, you have the right to public funding, so you have a right to get a lawyer to act for you. So generally you'd have representation, unless you just decide you didn't want them, which is up to you. So let's say the mother was the first respondent, then it's usually a barrister, it could be a solicitor. Counsel for the mother would then cross-examine the social worker. That would be followed by cross-examination by the second respondent. Let's say it's a father. Let's say there's a third respondent, a grandparent who wants to be special guardian, and then questions from counsel for the guardian representing the child. And that would be the order of questioning. And of course, when you have lots of different parties, if you're third in the row and your question's already been asked, you don't need to repeat it. So if you're acting, let's say, for the grandmother and the mother's barrister's already asked the very same question, it's been dealt with, you wouldn't then repeat it. So there's always going to be some overlap. But each party has the right to ask questions to cross-examine that witness. And there's court bundles, so they refer to the various pages, page 31 of your state, paragraph 16. You've said, when we went there were, 3 fierce dogs, and there was a baby there. No one was looking after the child, and we couldn't find the mother, but in fact, my client, the mother, was, in the next room and came straight out, something like that. I'm just making up, obviously, just a set of facts, but you'd ask the questions, and then they would deal with that, and the judge would be listening very carefully. So once everyone's asked their questions of that witness, goes back to the local authority, and then they deal with what's called re-examination, just to clarify any points. So if there'd been questions in cross-examination, then local authority have the right to ask clarification questions, but only on questions that have been raised in cross-examination. Hope it's making sense to you. So race through what would happen in the final hearing. So once the local authority that have given their evidence and gone through their witnesses, you can imagine this might take a day, 2 days. Then the applicant, usually it might just be the mother giving evidence, would go up and give evidence. And in a care case, you don't have the right to say, I'm not going to give evidence. You are compellable as a witness. I don't know if you know that, but letting you know that. And then, so if the mother then gives evidence, then the local authority, she gives evidence in chief, led by her own barrister, just a few questions. You have to ask permission to give evidence in chief, because you've already written your evidence in a statement. So you would confirm the evidence you've given in your statement, might answer 2 or 3 questions. Local authority would then ask you as a mother questions, then the father's legal representative, then the guardian, the grandmother's legal representative in that case, then the guardian's legal representative. So they would go through, and your evidence could take, couldn't it, half a day, and then your own representative would have the right to re-examine to clarify. So you can see the process that each party calls their own witnesses. There is examination chief, cross-examination and re-examination. Just in case anyone needs to know this, examination in chief is when a lawyer asks their own witness a few questions to clarify their own case. Cross-examination is when parties ask questions about their case where they are contesting issues, and so they would ask, it's where you're in dispute, so you're cross-examining, asking questions for your own client. And then re-examination is questions that clarify matters that may not have been clear from previous answers. Once all the evidence is given, that could take a number of days, then each party will give their closing submissions. And in a civil case, I've talked about the local authority opening, thank you, someone says great live, thank you. Always boosts me if I get a bit of positive comment as I'm talking, so I'll keep going then. Once the evidence has been given, then the judge will want to hear everyone's closing submissions. And as I've said, local authority went first in presenting the case, and in a civil case, the way it works is the people who are respondents go first, and then the local authority respond. And in children cases, the guardian always goes last. So the very last submissions are from the guardian. Always hear from the person who's representing the child last. Then the judge will give a judgment, and just because there's always some different things that happen in cases, there could be times through the case where there's a particular point where a judge has to give a judgment as the judge is going along within the case. And it might be the case that the judgment can't be given at the time. Given at the time, they use a Latin expression, ex tempore, and I can't even pronounce, ex tempore, yeah? So we like to have our little Latin phrases, so that would be giving a judgment at the time. And then, or it could be a reserved judgment or written judgment, which will be sent after. But judges like to indicate what the outcome is at the time, at the end of the hearing. So that's public law. Hope that makes sense. Going to move on to private law final hearings. And it's the sort of same idea, but in there's less parties. But I'll go through it as well. So in a private law case, you either are going to be before a judge or justices. And if you're before justices, there will be 2 or 3 of them. They are lay justices, they are members of the public who are trained to deal with family law, they're not lawyers, and they're advised by their clerk. If you're before a district judge or a circuit judge, it would usually be a district judge rather than a circuit judge, it could be either. They're usually the more complex cases. So the way cases are run is that if you are the applicant, you will in the same way do the opening. Again, that could be very brief because the court requires you to do a case summary and chronology, so it's already read what the case is about. But way it classically might be opened if you've got a lawyer would be, may it please you, I act for Jane Jones, and this is her application for a residence order for the children, and give all the details. Also in court is and introducing everybody and just saying a little bit about what the case is about. That's called an opening. What happens, and this is something I find happens very often in a final children matter, because the court can run the case as it sees fit, because obviously the court has case management powers. They don't have to hear from the applicant and the respondent and then the CAFCASS officer. Very often, more often than not, the court would say, we'd like to hear from the CAFCASS officer first. And there's a good reason for that. So hear from the CAFCASS officer who is a witness of the court. So it should be the CAFCASS officer should be led through evidence, usually by the judge, but it could assign that to one of the lawyers if there's a lawyer there. So Cafcass officer will give a name and professional address, and then will confirm the contents of their report. And usually the court asks, is there anything in addition you want to say? And then the parties will ask their questions of the Cafcass officer, and you have the applicant first, then the respondent. So let's say, I was saying earlier, it could be a father applying for greater contact. Let's say he wants to have children staying every second weekend, Friday to Sunday, and every Wednesday to Thursday. And the mother's case is that it should be pickups from home, 6 p.m. Fridays, returns on Sundays, lunchtime, and no overnights in the week is disruptive. You know, they're not, both cases are not unreasonable cases. It just depends on what's right for the child. And that hasn't been agreed. That's gone to a final hearing. It's quite a simple one, isn't it? I'm sure there's lots of scenarios that are more complex than that. But let's say there's a Cafcass report. It's got the wishes and feelings of the child, and do say hi in the comments below. I can see some people are saying hi, so hi to you. So let's say that the case is, that's what it's about. So each side would put their questions. Let's say in this example, both are unrepresented. And so let's say it's father's application, he'd go first, and sort of questions he might ask about how much better it is that, you know, he can collect from school and speak with the teachers, you know, at the school gate, and see the other parents. And, you know, it's much nicer not to have to return the child on the Sunday at lunchtime, because then they get the time in the evenings, and the child's expressed a view, wants more time with dad, and how that's going to work, and how the overnight. So those questions along those lines. And then mother will put her questions to Cafcass officer. And what often courts may do is, at the end of that evidence, they might then give the parties some more time to discuss things, because the court will usually follow, well, it's a rule, it's in a case law, the court should follow Cafcass's views unless there is a reason not to. So it doesn't have to follow them, it's the court's decision, but it would need to explain why it's differing from the evidence of Cafcass. So often the court will give the parties time to have a discussion. Let's flip it and say they're both represented in this case, so the lawyers might go out and it might come back in with an agreed order. And that is the benefit of having Cafcass giving their evidence first, because it can assist settlement without parties having to give evidence against each other, which can be damaging long term. It's not the best situation. Sometimes it has to happen, but it can cause, you know, long term upset. It's much better if the parties can agree. And then, you know, if you think about it, they've both put all their questions to the Cafcass officer. They've heard the evidence, they've tested it, and then they're in a better position to really look at it after that evidence. And that's why often Cafcass goes first. In other cases, I think there's a recommendation there. I'm looking, FSC, excellent, thank you. That's what we try to do. We put this content out there so you get an idea of what we're trying to do. We're trying to empower people, give them more knowledge, you make more choices. Obviously, sometimes you need a lawyer, sometimes you don't. That's what we're trying to do. Now, let's say a different scenario. It might be that the parties would say, the Cafcass officer might take the view that let's say it's she hears both parties give evidence, because there might be some value in that. And that's what I mean about that's flexible. So the order of witnesses can vary, and it can vary more in private law. That's my experience, whereas, you know, with public law, it tends to be more set. I think perhaps because there are so many parties, it's just a sort of a more set pattern, whereas in private law, there tends to be a little bit more variation. So sometimes it could be a value in the Cafcass office actually sitting in and listening to the witnesses, something to think about. You know, there could have been an update, don't know. There are cases where particularly magistrates like to do this, where they actually say, we don't want to hear the evidence of either the parties, we only want to hear from Cafcass, and then you can make submissions. So be prepared for that, because justices like that. They feel that if they hear from Cafcass and there's cross-examination of the Cafcass officer, they feel that both parties can then just make submissions. And that might be right. It just depends on the case. That might be the best way forward. And they usually raise that. We don't need to hear from the parties unless, you think there's a reason that they should each give evidence. So when magistrates are dealing with cases, perhaps because they're the simpler ones, often they would just hear evidence from Cafcass and then each party makes submissions. Okay, but let's say that each party is giving evidence, then it would be for the applicant to go into the witness box and give evidence. You can't take anything in with you. Sorry about that. I know people always like to, they want to take a batch of notes and then they have to be told, no, don't take anything in with you. The only thing you should have in the witness box is the court bundle, okay? You can't start pulling out other bits of paper. Or your phone, check things on there. Or look for someone else to give you the answers, whatever. The bundle's there and you're in the witness box. Now, if you're represented, then your lawyer will ask you a few questions in examination chief just to clarify things, take you to your witness statements, check that they're true. If you made a mistake, and sometimes people put the wrong date in a witness statement, you correct that at that stage. Then the other side, and it would be... then they have a chance to cross-examine you. So if they're represented, it will be their solicitor or barrister asking you questions. Now, one of the things that's difficult is when parties are not represented, because then there's a scenario where a father might be directly questioning the mother, let's say, and that's obviously not great. That's obviously really tricky. So there's ways around that. If there's been domestic abuse, that's a whole new scenario. I'm not going to really go into that now. I'll talk about that on another live. But let's say there's been no abuse. There's it's just no welfare issues. But still, one of the parties cross-examining the other isn't ideal. And one thing you could do in that situation, that person could write down the questions, ask them to be put through the judge or through the justices or the clerk. But if you do have to cross-examine the other party, or if you're the one being cross-examined, please do remember it's not a conversation between the two of you. It is one person putting questions about the issues and then you as a witness looking at the judge or the magistrate and giving your answers. Because I've seen this quite a few times, and it is unfortunate. People always get into a sort of domestic argument and we all think you're supposed to be giving evidence, not just going off on a tangent about something that isn't relevant to these issues. But I totally appreciate how tricky it must be if you have to cross-examine the father of your child or the mother of your child. It's really tricky, and that might be a really good reason for having a legal representative or having a Mackenzie friend who can sit beside you and just take notes. They can't talk, but if you had someone there with you. Witness goes in, it's cross-examined, and then then there could be re-examination to clarify anything that's arisen in the cross-examination. So the applicant does that. Let's say the applicant's a father, he's given evidence first, he's been cross-examined, and then the respondent goes in, mother, she gives her evidence. Then after all the evidence has been given, and usually private law cases are a lot shorter than care cases, because obviously there's fewer people. So let's say it's a day's hearing, or it could be 2-day hearing. Then after the evidence has been given, each party makes their closing submissions, and it's for the respondent to go first and the applicant then follows. And then again, people get confused if they're doing this themselves. Asking questions is different to making submissions. Your closing submissions is your statement, it's your closing statement. And as a lawyer, I always prepare a case around where I'm going to go to at the end and what I want to say at the end. So my questions are always designed to get to my closing statement because I know my case. So in the same way, if you're preparing for a case and you don't have a lawyer doing it yourself, split it into, what's my opening position, what are the questions I need to ask, and what's my closing statement going to be? Because the closing statement is where you say what you want to happen and why. Just as simple as that, really. So write your closing statement before you start. You might have to move it around a bit from things that have happened within the hearing, of course, but you should always be heading towards that. And then you make your they're called closing submissions. You make your closing submissions, and then the judge or the justice have heard everything that's said, and then they need to make their decisions. Now, the nature of family law is that when you're making closing submissions, certainly for a lawyer, if it's a judge, they will intervene and just say, I don't need to hear any more about that, or just tell me more about this, or ask questions. I always make sure that when I finish, if they haven't asked questions, is to say, this is all I have to say. Are there any questions or any points that you wish to raise, just to give them that opportunity, because I'd hate to think that they were sitting there and I'd just been talking about the case as putting the points that I thought were important, and that I'd missed something that they really considered important. So I think it's really important at the end of your submission to say, this is what I want to say. Are there any points I can assist the court with? Something like that. And then if it's justices, they will retire, consult with their clerk, and then you'll all go back in and you'll hear the outcome, and they give written reasons, and then they write up the order. If it's a judge, it could be that the judge would go straight into giving a judgment, or might say, I just need 30 minutes and send you out. So they're usually a bit quicker because obviously they are professional lawyers. So now I've got a request for someone to be in the video. Because I'm coming to the end, I'm not going to join you, but it's a great, if you want to be on a live, then send us a direct message. We can do a live and get you into it. I don't want to keep people too long by joining anyone at this stage, but I hope that's been really helpful. Send us a direct message if you want us to cover different issues, or you've got a particular query about anything I've spoken about. It's a live, so don't expect me to be perfect here. I'm just giving a general guidance. There's all sorts of different ways things can happen, and the other thing to remember is the court controls its own conduct. So if the judge decided to do it completely differently, you couldn't object as long as it made sense and it was fair. But I've given you the usual order of things. So, but if a judge wanted to hear from a party out of order or change the order, then the judge would normally say, this is what I intend to do. And as long as it's sensible and fair, then you would just go with it. But I wanted to give you an idea, and I hope that's all been helpful. So I'm going to say bye now. I hope you have a great evening, and I will see you on Sunday. Bye-bye.